Mhm.
It's working. It's recording.
Perfect. Thanks.
Sorry, I should have stated that.
Hi, everyone. Thank you for joining. I will wait a little bit more to wait until more people can join us, and then we will start. I will just give it another minute. Right. Hi, everyone. Thank you for joining us for our New Developments in Immigration session. My name is Lana Morozova, and I'm the International Services Coordinator at the International Student and Scholar Services. And I primarily work with scholars at the Anschutz campus. And with us today, we also have Anna Inazu and Tyler Stokes. These are our international services specialists that work primarily with students at the Denver downtown campus. And our speakers today are immigration attorneys Bob Aronson and Deborah Schneider from Frederickson and Byron. And we work really closely with them on most of our employment-based cases. And they will be covering the developments in immigration. We'll also touch a little bit on travel restrictions. And we will also have some time left at the end of our session so that we can answer all the questions that you might have, or we'll try to answer most of them. And Anna and Tyler, they will be monitoring the chat and the Q&A section during this meeting. And we ask that you please submit your question using the Q&A so that we can either answer your questions live, or we will be saving them to the end, and then we will address them at the end of our presentation. And with that, I would like to pass it to Bob, and thank you again for helping us out to inform our students and scholars on the new developments in immigration.
Well, greetings, everybody. And Lana, thank you very much. Deborah and I feel very honored to have an opportunity to speak with you. And we're very grateful to ISSS for the invitation. And our goal really is to expand on the commitment of ISSS in creating meaningful educational opportunities for the CU community. So what we want to do today is to really kind of start with the fact that there was a major tectonic change that took place on January 20th with the inauguration of the Biden administration. And with that came certainly a new approach to immigration, as well as various ancillary related issues. So what we want to do, and obviously we're very early in the Biden administration. We're really at just over the 60-day mark. But we want to sketch out what, in a sense, is Biden's vision for immigration. Where does it stand? What are the both impediments to widespread enactment of his program and the prognosis for success. And then what we want to do is to focus in on certain situations that exist today as we're making some type of pivot, some type of transition into a new culture in immigration, to take a look at where do matters stand with international travel, what's going on in the H1b temporary worker world, and various options for permanent residence, and then dealing with the inescapable reality that we're dealing with substantial delays. So I'm going to be doing the first half of the program, dealing kind of with the overall global initiatives and vision of Biden. And then my colleague, Deborah Schneider, is going to pick up matters to look on a little bit more granular basis on what does all this mean for you in terms of your immediate needs for travel, for visa coverage, for permanent residence. Okay, next slide, please. So where do we stand? Again, with the proviso that we're at a 2-month mark, very early. There's unquestionably, Biden ran on a platform and has certainly continued in articulating a vision in the early days of his presidency of wanting to inject a good deal more humanitarian values into our immigration system. And that in many ways manifests itself in new policies to portions of immigration law that either do not affect you or only tangentially affect you. So it's things like affording protection to people facing persecution through our refugee program, through asylum, through various types of protective services for children, and certainly for the dreamers. Having said that, he does have a vision of updating and modernizing our immigration system. We're in there are certain factors that really suggest the need to revise, update, modernize, streamline our immigration system in order to recruit and incorporate thought leaders. And certainly you, as members of the CU community, fall within that classification. I mean, we've had a drop-off of about 40% throughout the United States in the number of international students and scholars coming into the United States. And this is the feeder line for future leaders within the United States. And we also, and just demographically, we've had with COVID a drop off about 300,000 in the birth rate. So immigration has major impacts on the overall competitiveness and economic growth and social betterment in the United States. So even though the Biden administration has this heavy emphasis on humanitarian issues, there's certainly provisions in the Biden platform, in the Biden administration, for certain provisions that will affect and largely benefit students, scholars, and high school workers. And that's what we want to focus on today. So next slide, please. Before launching into Biden and his vision, let's talk for just a second on US civics. There is some desire for the transformation of US immigration laws to occur overnight, to have it done quickly. But that's just not quite how our system works. So in order for a new law to be enacted into the US system, we have to figure out where it fits within the legal structure. So at the very top of matters is the US Constitution. So that lays out the overriding but broadly stated laws and policies of the United States. Under that is statutes. So those are laws that are passed by the Congress, signed by the president, and they have a very powerful impact on US law. So the Immigration and Nationality Act, the core document that creates our immigration system, that's a statute. So it went through significant discussion, vetting, and a very rigorous journey leading into law. Again, the statute is narrower than the Constitution, but it still is a broadly stated articulation of US law. So what it does is it creates general provisions within our laws, but then it becomes up to various agencies to carry out the statutes. So the main one in immigration would be the Department of Homeland Security, in particular, US Citizenship and Immigration Services, but other agencies also get involved. They promulgate regulations. So an agency regulation is basically the rules governing a federal agency conduct. And in order for the agency to promulgate and implement new regulations, there's a pretty rigorous set of requirements that they need to fulfill. They need to obviously draft the regulation. Then it gets published. The public needs to be notified. The public has the right to comment on the publications, suggest changes, feed in how this would really impact the United States. Then the agency has to account for the comments and finally issue a final regulation. All of that takes quite a number of months. And in many instances, it's really regulations that need to be changed in order to change immigration law. Under regulations, there's certainly broad areas that simply are unaddressed by either the statute or the regulation. It's kind of like white matter in a way. And here, the executive or the president has significant latitude to unilaterally issue directives to create kind of new policies, or the agency can also issue directives. But again, it's only in specified areas that are consistent with the statute, which are consistent with agency regulations, but simply have gone unaddressed. And overseeing all of these different moving parts are the courts, to make sure that no one is overstepping. And we've certainly seen countless instances where executive orders get struck down by the courts as being an overreach, as going too far and invading areas that are more properly addressed through regulations or statutes. So my only point is you need to figure out what the appropriate course of action is and where in US civics remedial provisions would fall. Okay, next slide. So Biden gets into office on January 20th, and he really does not lose too much time in proposing a really quite a sweeping immigration bill, which was introduced in the Congress on February 18th, the US Citizenship Act of 2021. It is largely directed toward humanitarian provisions, toward immigration enforcement, but it does have certain provisions that, if enacted, would apply to you. So let's go through them pretty quickly. One of the things, and this is in line with Biden's desire to harmonize and modernize our immigration laws is a desire to reduce substantially visa backlogs, to reduce substantially the wait times that you would be experiencing in going for permanent residence. This bill does not raise the overall number of green cards that are in the US system. So if you're getting a green card based on employment, right now there's 140,000 green cards available, and of that amount, no more than 7% can come from any one country. The Biden bill does not raise the overall quota, but what it does, and this would be very important, is under current law, if someone is getting permanent residence, then his or her spouse and children also claim immigration visa numbers. So even though the central applicant, based on a position, let's say at CU as a professor, the whole case is structured on the professor's case. A family of four will draw down 4 immigrant visa numbers for this 140,000. So what the Biden bill says is we're only going to have one debit against the overall quota. That in and of itself will preserve a great number of visa numbers. Then it says, over the years, we've not used up all of the quota numbers, all of the immigrant visa numbers, largely in family-based immigration, and we're going to create new mechanisms to rotate those numbers into the employment-based quota. So again, it will make more green cards available in the US for employment-based immigration. It also reduces the wait times by creating new expectations, how long it will take to get an employment card, how long it will take to get citizenship, and so on. The Biden bill eliminates this 7% limit, which will substantially help, in particular, natives of India, although there's a possibility it will lead to backlogs. And the process of reducing the Indian backlog, it will lead to backlogs in other countries. The bill also recognizes the intrinsic importance of getting STEM professionals to remain in the United States. So what it says is, it has a provision which says, if you have a PhD in a STEM discipline, so science, technology, engineering, or math, that you will have a more immediate, streamlined approach to permanent residence, pathway to permanent residence under the national interest waiver. But then in addition, you'll be exempted entirely from the quotas. So that would be a big step forward. Next slide, please. In addition, it says that if you're in H1b, that your dependent family members, your spouse and children can all get employment cards. Right now, only the spouse can get employment cards, and under the previous administration, the Trump administration kept threatening to remove the ability of a spouse to get an employment card. Well, this says once and for all, we're not only going to make available employment cards to spouses, but also for children. And that in this manner, it's an initiative intended to stabilize families. It's a great provision. In addition, the Biden bill says that it gives increased protection to get children to attain permanent resident status along with their other family members. Under current law, if you have a family and you're going for permanent residence, but by the time the case is approved for permanent residence, a child is over 21 years of age, the child may become disqualified from getting permanent residence. What the Biden bill says is, look, if you start a case for permanent residence and the child is under 21, the child gets grandfathered as part of the family unit. So even if the child reaches 25 or surpasses 21 years of age, they can still get their green card along with their family members. The last major provision I want to call attention to in the Biden bill would be something great for this audience. And what it says is that our laws will recognize dual intent for F1 students and J1 scholars. So as you probably know, in order to get a visa, in order to remain in the United States, in order to travel, you have to continue under an F1 visa or a J1 visa. You have to continuously assert and oftentimes prove that you have an intention of going back to your home country. What this would say is, yes, you still have to maintain temporary intent for getting an F or A or J, but in parallel, you can do a case for permanent residence. And as long as you can have a future intention of getting permanent residence, we'll let you get an F visa or a J visa. And it would simply inject a great deal of foreseeability and stability in your ability to get visas, to travel, and to commence cases for permanent residence even while you're in F or J. Next slide, please. Okay, so what's the prognosis for getting this entire Biden bill passed? Roughly the same as winning the Colorado state lottery. Not so hot. Why? Next slide, please. Right now, there's a perceived crisis on the southern border where you've got populations of asylum applicants stuck in Mexico, where you've got families separated, where you've got children coming into the United States. It's kind of a mess, or it's perceived as a mess. And the belief is, and it is an issue of substantial political vulnerability to the Biden administration. So the belief is that he's not going to be able to press ahead on his overall immigration objective unless and until he gets the southern border situation squared away. So when I go through the provisions in the bill I just did, those are aspirational. That's kind of a wish list. Don't hold your breath on it being passed. Elements of the bill may be split off and passed as separate pieces of legislation, but the bill as a unified re-engineering of the immigration system probably will never see the light of day. Next slide, please. So what's been accomplished so far? Let's go through this real quickly because we've not been standing still. First of all, the Biden administration has rescinded the Buy American, Hire American, or BAHA policy, which basically said that a central objective of the United States is to buy American goods and hire American workers. And what that overlooked is that foreign nationals, particularly H1b workers and permanent residents, generate jobs, generate income. They're good for the economy. As long as BAHA was in existence, immigration had a green light to reject immigration cases. This kind of moves the ball and gives increased latitude for immigration examiners to approve cases because they're no longer perceived as the guardian of the US labor market. In addition, DACA has been protected. That is the Deferred Arrival Program for childhood arrivals. So what it does is it gives kids who came in with their parents increased protection, increased stability. The Biden administration has rescinded the travel ban, which was largely focused on Muslim individuals. The Biden administration, and Deborah's going to deal with this, has created some new provisions in defining what the required wage is for H1b cases and 4 cases for permanent residents. And by the way, today was released a major new directive in the calculation of wages. So this is good timing for this program. In addition, the Biden administration, under law, a permanent resident cannot take welfare. But what the Trump administration did is it created this huge new application through which you had to prove that you had sufficient financial means not to go on welfare. It was like an 18-page application and quite intrusive. And the Biden administration has said, wait a second, if someone has a good salary and can show a record of being able to sustain him or herself, chances are that they're not going to need welfare, and we're not going to force them to go through this terribly time-consuming and intrusive process. Next slide, please. In addition, the Biden administration, through its own action, has preserved the H4 EAD rule. The Trump administration had created a new proposal that would substantially penalize F students and J exchange visitors if they lived in the United States beyond their allowed period of time. It created the basis for long-term ineligibility to come into the United States. The entire academic establishment, including the University of Colorado, filed many comments in opposition to this. There was something like 25,000 comments. And the Biden administration has withdrawn that. It basically has said that it will not change any penalties for F and Js for overstaying. In addition, the Trump administration had created a special compliance unit looking into whether an F1 student was complying during periods of optional practical training. That's been rescinded as a federal investigative function. The ISSS still has obligations to ensure that an F, or for that matter, a J, foreign national in OPT is adhering to their obligations, but it rests primarily with the university to report rather than having an intrusive federal agency poking around with things. Biden administration has lifted certain bans for the issuance of H visas and permanent residence. Deborah's going to go into that. And the Biden administration has also reinstated a policy of recognizing that an expanded list of computer professionals should qualify for H1b visas. These are all very positive things. Finally, the Biden administration has liberalized somewhat the naturalization process. And Deborah's also going to talk about the H1b lottery. They've injected a greater level of stability into that process. That is a process, if you're going, let's say, from the University of Colorado, Denver, into the private industry, and you need an H1b visa. What has not changed is the basic architecture of the immigration system, the quotas, and the ways in which you get permanent residence. What is of particular concern is that we still have somewhat of a culture of no at the working level. And this becomes particularly concerning for a number of cases that involve the exercise of discretion. Are you of someone of outstanding ability? Is the work you're doing benefiting the United States? We're still seeing immigration examiners taking a very jaundiced, a very skeptical attitude toward these types of requests. It's going to take a while for the culture to change. There's certainly a lot of international travel uncertainties. Again, Deborah's going to deal with that in terms of disruptions in consular operations, certain countries being subjected to either quarantine requirements or restrictions and visa issuance and so on. And then there's huge delays, there's huge backlogs. Those all remain as part of the system. Whether we change the time or not, we'll see. But we have to deal with them. Okay, next, please. So with that, we've gone through kind of some of the basic global overview. Let's take a look on how it plays out in your own immigration life. And with that, Deborah Schneider's gonna lead us through that discussion. Thank you.
Thank you kindly, Bob. And I understand that many of you may have previously attended a seminar put on by the International Student Office on employment base, but hopefully this will provide you with another reminder and some current information on what the environment looks like post-graduation, right, or post-work at UCD. The main pathway that most individuals, especially foreign students after graduation, pursue is looking at an H1b visa. Obviously, the first thing you may get is OPT, which would allow you to work for 12 months. And for those of you with STEM disciplines working for an employer who is registered under E-Verify, you may also qualify for the 24-month STEM extension. I'll also provide a short overview of some options for securing permanent residence on the path to a green card. So first, let's just talk about the basics of an H1B. It's essentially for those working in what's called a specialty occupation. So they're looking at three main factors. First of all, does the individual themselves possess at least a bachelor's degree, a foreign equivalent of a US bachelor's degree, or the equivalent in experience? Then we have to look at the occupation. Does the job that's being offered to the foreign national require as a minimum entry at least a bachelor's? Okay, and how this is determined, there's actually within the regulations 4 prongs to make that determination. And the Department of Labor also has a published group of listings of occupations where they've established zones, which determines how much education or experience they believe is necessary for a position. On top of that, once those have been established that the position is professional, then the employer has to file a labor condition application. And within this application, it's attesting that it's going to be offering the same working conditions to a foreign national as it would a US citizen. Within this, it's also attesting that it hasn't had any layoffs, and that it's agreeing to pay what's called the prevailing wage. Now, what the prevailing wage is a bit of an amorphous concept. So within the Department of Labor, they do have a published 4-tier wage scale. It's called the OES wage scale. And this is considered a safe harbor, meaning if an employer uses these wages in their H1B, they're going to be considered to be paying the prevailing wage. And what had been addressed is under the last administration, a regulation had been proposed which would revamp the entire prevailing wage system. And it went up substantially, 30 to 60% in some cases. Which essentially would mean employers would have a very difficult time in being willing and wanting to sponsor an H1B non-immigrant because the wages would be outside of their normal wage scale, right? These were really unrealistic. What it also allows employers to do is use what's called private wage surveys. So if the government's wage data is inconsistent with the prevailing practice, they can look for outside surveys, which says we've run our own tests of the labor market and we really believe XYZ is the correct salary. So groundbreaking news, literally as in about 10 minutes ago, received notification that Monday, likely in the Federal Register, will be a publication that this proposed wage change will be essentially bumped out until 2022 with potential effect in 2023. So what that means is there's a reprieve. No one has to really deal or worry about this new headache for at least another year. So good news today, yay. Let's be thankful because that's going to really, I think, continue to open up doors as the economy improves. So if you're not working for a university, you have to deal with what's called the H1b quota. And there's a quota because by statute, there's only 65,000 visas that are available to H1b workers for the entire country, with an additional 20,000 for those with at least US master's degree or higher. And so that means that individuals are going to have to enter into an H1b lottery every year to see if they can qualify into one of these quotas. So there's those who are capped exempt, which I'll go into next, and everybody else who's going to be subject to the quota. So for those who are quota exempt are universities. So if you work for University of Colorado, you may know you were able to file an H1B at any time. So you don't have to enter this lottery. Universities are special status because of the importance of being able to engage in research in the United States, so they've been exempted out. Who else is exempted are nonprofit and university-related institutions. So if you're a nonprofit that's associated or affiliated with a university, and there are strict rules on what constitutes that qualifying relationship and affiliation agreements, you can also file a cap exempt H1B for an individual. If you work concurrently, so say you're currently working right now at University of Colorado, but then you're offered a part-time job with your friend who did a startup company and would love to have you work on computer programming. They could sponsor you for a concurrent H1B as long as it runs in tandem with the university's petition. Okay, so that does provide some flexibility, but at all times you have to maintain your university cap exempt employment. Other institutions that are cap exempt are government research organizations, international medical graduates who qualify for what's called a Conrad 30 waiver are going to be cap exempt, or if you've already been counted in the quota. So this quota is the H1B lottery, and when you've won it and you've worked under it, if you move to another employer, that cap exemption then follows you, right? So then you are considered cap exempt, and the new employer can, quote unquote, transfer the H1B. Really, they're filing a new H1B. What they're transferring is the fact that you've been counted in the H1B lottery, and you don't have to go through it again. There's also a unique distinction for those who are employed at. So say you work for a private company that's not affiliated with the university in a qualifying capacity, but if you're going to be physically working at the university but paid by a private employer, you may qualify for an exemption from the H1B quota if there's a provision to show that that's benefiting and aiding the university. So there are some exemptions that are always important to look at because it could allow you to begin working right away. So those are essentially the main benefits of being under a cap exemption. What happens if you're subject to the cap, as most individuals are? Well, you're going to enter the H1B lottery. The H1B lottery is run every year. As of last year and this year, it's run through a computerized random selection, which is open. Actually, it closes. It's open right now. So if you have a job, file right now. It's open through noon as of March 25th is when it closes this year. And why is it done every spring? It's kind of like Passover and Easter. Like, why does it every year? Well, it's because the government's fiscal year begins October 1. And the soonest you can file an H1B petition is 6 months in advance, which would be April 1. So in the old days, prior to this computerized system, you literally had to file an H1B petition, the entire petition with fees for delivery on April 1st within a 5-day window. To be selected literally by hand or manually. Now there's an electronic system that will run the basic information, determine who gets in, and then you have a 90-day window to file. So why is it a lottery? Well, I gave you those numbers, right? 65,000 or 85,000 if you with the U.S. Masters at extra 20. On average, each year there's around 200,000 applications. So you have about a 1 in 3 chance of getting selected in the lottery. So that's why we call it a lottery, because it's that random. So the timing is, this is why, getting your OPT, having STEM OPT, and getting an employer to sponsor you, raising that need for sponsorship timely is important, because you only have this window. Once this window closes on March 25th, it won't open again until next year, and there's no opportunity to file for an H1B. Fun stuff. So let's talk, oh, and I did this before and I did this again. I just want to note for you J1 scholars, because this is something that we've been working closely with the ISSS office when, for those of you who may be subject to 212E, the 2-year residence requirement, you probably have seen or heard from others is that getting a waiver of that requirement, often through a no objection waiver, is taking a really long time. What used to be a quick, 4 to 8 week process is now 4 to 8 months. And so those delays, if the timing of that waiver is not secured early, it's going to prevent you from getting an H1B. And we're seeing people run up against the end of their potential 5 years of J time, or Department of State is not allowing changes from different programs, and those risks are real. And so it's really important, if you're looking at continuing on your studies at the university and needing a cap exempt H1B at all, to start that waiver process as soon as you can. And now I'll go into what many of you are interested in, is getting green cards, right? Maybe the US has now become your home. It's a place where you've realized this is where you'd like to build your career, and you're looking at, what are my long-term options? Where are my prospects? Well, what we've listed here are really the main areas where individuals will get employment-based sponsorship. Obviously, there's other ways you can get it through family sponsorship or marriage, but we're going to talk about kind of employment path. The first one is what's called the Perm labor certification. And this is when an employer does a test of the labor market to see if they can find a qualified US citizen to fill this position. Generally, an employer is only going to sponsor you for a Perm if you're already working for them, right? So if you've already established an H1B, or for certain individuals, you may even do this as an F1 student if you qualify for STEM, because that 3-year period of time may be enough to get you along the path to a green card. So it requires them to pay a prevailing wage, to run a series of recruitment, and it is a good path to permanent residence for many individuals, either in EB3 or EB2, unless you're from India or China, where the backlogs can make it more difficult. And this is the primary path, I would say, for most individuals, unless you're a researcher or outstanding, and I'll talk about those next. So if you are currently a professor, either tenure track or engaged in research with long-term funding, the university can sponsor you as an outstanding professor or researcher. This does require you to be considered outstanding within your field of research, and you have to prove this through documentary evidence, for example, by including publications, awards, original research, expert letters, and it has to be of a caliber where, compared to others in your field, you're going to be considered outstanding and highly prominent. So it does require you to be good and have an ego to help express that, and others to believe and give that same value. Both of these are employer sponsored, meaning your employer, say the university, must be the petitioner. They have to agree to sponsor you for these petitions. If you are on your own, you don't know where you want to be, where you want to work, or you want to have greater flexibility of movement between employers, you may look at self-sponsored applications. The first one is for those of extraordinary ability. So if you're at the top of your field, whether it be in arts or sports or business or science, this would be the path that allows you to self-sponsor. So you're filing a petition on your own to the immigration agency, establishing how you're so extraordinary at what you do. And there are 10 enumerated criteria, and you have to meet at least 3 of these, as well as show in totality why you're considered the best of the best. And so, as you can tell, this is one of the hardest categories to meet and does require an extremely high level of accomplishment and acclaim to get. Another possibility is filing for a national interest waiver. We'll call it a step down. It's really a different type of analysis, right? This is then looking at saying what you've already accomplished to date and what you're going to do in the future. How does this establish that you're going to benefit a national interest of the United States? This could be healthcare, this could be the economy, this could be national security. What are you doing, and can you provide support to say, if the US lost your continued work in this area, it would be detrimental to the US national interest. So you're going to want to support this. So there are paths to allow you to secure a green card, whether through your employer sponsoring you, or yourself if you've reached a certain level to get you there. One of the things we do when assessing this is to look at kind of the full picture, both where you're working, where you're going, and who you are. So things we have to think about are the quotas that Bob had talked about, right? If in EB2 visa or EB3, which is the preference categories, for most countries, either one is current right now. So you can either an EB1 or an EB2 would be just fine for you. However, if you're from India or China, you may have a huge preference to try to get in that EB1 category, because it's going to save you maybe 8 to 10 years of wait in this immigration line. So those are the backlogs that we're looking at. How quickly do you need to have your green card? Is premium processing available or not? What country were you born in? Because it's your country of birth that actually establishes your place in line. How long will it take? Do you have any children that could age out where we need to quickly get a petition in right away, or do we have time? And then the use of discretion, as Bob had noted, Right now, the agency is still in a fairly aggressive use of its discretion. That's not always to the advantage of immigrants and foreign nationals. So we want to be thoughtful about if we have a very clean path to a perm where someone has a very rare skill that's hard to find, that may be a surer way of getting it than relying on whether someone had a good or bad day when they saw your case, right? If they have to use discretion. Do you have institutional support? As I explained, the perm or outstanding researcher can only be filed by the university. So you would need to have your employer be the individual to actually sponsor you. And we'll send this out as a link, but a great primer to read is an article that Bob wrote called 10 Keys to Attaining Permanent Resident Status for Postdoc Scholars. It's really useful in outlining kind of what I've just discussed and what may be pertinent in your particular situation. And at the end of the day, the agency is looking, primarily at where's the individual strengths and how do their metrics. And when I use those terms, I mean, how many publications do you have? What's your citation record? How many presentations have you made? Have you served on significant panels? Kind of looking at in a more less thoughtful way, but kind of more comparison, right? Apples to apples. And you need to meet a certain profile or you're not going to qualify for these paths. So I'll move on to travel restrictions because I'm sure many of you have had questions about how do I go home, right? Is it possible for me to visit loved ones? Can I get back? And I will speak for the ISS office where I know they would ask you to please reach out to them specifically before making travel plans so they can advise you personally on any risks and make sure you have the documentation needed. Because what we've seen under both the former administration and the current administration is we have travel bans. Where the prior administration, the travel bans were imposed based upon, well, a variety of reasons, but not necessarily COVID. The first one that did come out from COVID under the prior administration was a ban from China, right? COVID emerged and all of a sudden we needed to close our borders to prevent the spread of disease. This was expanded within a month to the Schengen area, then the UK, Ireland, Brazil, South Africa, and Iran are all on the list. So if you're traveling from these countries, you don't have to be a citizen of these countries, you're just traveling from these countries, the US has imposed a 14-day ban on being able to enter. This means that if you've been in those countries within the last 14 days, you are not going to be granted permission to enter the United States unless you have a waiver or unless you spent 14 days in a country not on this list before coming into the United States. Other restrictions that we have in place are the land border between Canada and Mexico is currently closed unless you're an essential worker or have relatives or certain other exemptions. Now, it is safe to still fly into both those countries, but again, you're going to have to, Canada has some very strict quarantine requirements and limitations, so please visit that before you go. Mexico is more open, but it's getting much more difficult if you're looking at third country visa issuance. Visa suspensions. What did pass was in June of 2020, there was a ban on getting new visas for H, L, and Js if you were overseas at the time that order was proposed. That is still in place. It's in place through March 31st. We do not know yet if it will be extended beyond that date. But there's individuals who, for example, had an H1b cap approved from last year and still have not been able to enter because this ban remains in place. Now, there are exemptions, which I'll talk about on the next slide, but please be aware that there are still travel restrictions going on for these various reasons. Consular processing. So it used to be nearly impossible because of the ban to get an immigrant visa abroad, and now that's changed. I can say that all of a sudden we got a slew of emails from the National Visa Center and Embassy saying we know the ban's lifted, we'll be processing cases, but we should be realistic that it still could take almost over a year to get through the backlog. Embassies are yet to start scheduling those interviews, and we expect it to still take quite some time. And so in many cases, if you're traveling to get a visa, you may need to request an emergency appointment. We're seeing many consulates not able to open or get interviews until September or October. So that's really pushing out your ability to come back if you do need to go back home. There are some basis that the consulate can grant an expedited appointment, but certain embassies are still closed. Nepal hasn't opened. And others are only open to individuals from that country. So they're not even accepting any third parties. So you have to be very diligent and look at the embassy before you travel. So what do you do if you're subject to these bans, right? You still need to travel. You may have a legitimate reason. Well, we need to look at what exceptions you may qualify for. So individuals who may have a US citizen or permanent resident spouse, child, sibling, parent, essentially your family unit, you are exempted from the ban. So we would recommend traveling with your marriage certificate or your child's birth certificate to provide you with an exception in order to be able to be board the airline and come to the US. If you're coming in as a J1 or F1 student, you currently have a visa, you're going to be exempt from those travel restrictions. If you need a visa, however, you still have to get your visa stamp. And while you may be exempt from the bans, it's still extremely difficult to actually get the visa, again, due to embassy closures and delays. And so trying to get those emergency appointments would be very important. For anyone traveling from the Schengen countries, this administration has revamped its national interest exemption by denoting a critical infrastructure. And what this means is they're looking to grant visas for those who really need to be here to engage and work for areas of importance to the US right now. So people working in healthcare, people working in transportation, in IT, in security. And one of the things we're finding is they want to know is, can you do this job remotely? And if you can, they don't really see the need for you to be here. But if you can attest that you have a job that's hands-on, right? If you're a doctor, you need to be here to treat patients. If you're working in, you need to revamp someone's supply chain and their system's broken and you need to come in to fix it, they're going to grant those type of petitions. So it's a very one-on-one analysis for each individual. There's not just a broadband grant of exceptions unless you, again, meet those minor exceptions within healthcare or family ties. So be very thoughtful before traveling. Also, take a look at the country you're going to. They may have their own quarantine requirements and their own restrictions. And don't forget, international students, you have now been granted that exemption when coming in, but if you don't have that visa, you're still going to need to get that appointment. And then the US has imposed a negative COVID test requirement. Even if you've been vaccinated, you have to present this within 72 hours before you board your flight. And I say that because people have had it, the flight gets delayed, their test has expired and they can't get on the plane. So you really have to be working really thoughtfully about where to go, where to get before you're going to be granted entry. So thank you so much. We're going to leave this section open now to questions. And I think, Tyler, if you have any, Bob and I are welcome to take them.
Certainly, thank you both. Yeah, we have several. Just give me one moment here. So our first one that we had come up earlier during the H1b section was saying, are there changes in the H1b renewal process? How early should we be filing for renewal?
Great. So by regulation, you can only file 6 months in advance. So that's the soonest you can file. And it's always helpful to file, as early as you can. However, please note that there is a 240-day period that allows an individual after an H1b is extended to continue working lawfully in the US. Though we do know this has also created some questions with getting driver's license renewed. So it is helpful to file at that 6-month mark or soon thereafter when you can.
Thank you. The next one is asking, would we also see a decrease in wait times for other visa change requests? I'm assuming they need potentially aside from H1b. As of now, the wait time is 13 months for certain processing centers. That's what they're saying.
We've never seen processing times like it is right now. So let's start from the premise that what we're seeing right now is not the new normal, but it's the aberration. Not if we have, I think, a new attitude toward immigration and a greater professionalism and more consistent direction, as well as accountability within the program, I think we are going to see some substantial decreases in wait times.
Okay, thank you.
I will just caveat that I hope so. And maybe I'm not as optimistic because I usually am, but I'm giving up on almost because I feel that there's a worry the agency still, I think, wants more money. And one of their ways of doing so is to explain their backlogs, and they need to hire more officers and need to raise fees. And they didn't get their fee increase that they asked for before. And I think you may see some fighting between the agency and between the directive of where they need to go, because I think there's going to be some conflict because their the crisis that things are taking is, I mean, it's preventing individuals from feeling secure here.
This next person asked, would research-based hospitals like University of Colorado Health be considered university-related institutions?
I don't know UC Health intimately, but the general rule is if it's a nonprofit teaching hospital, then it should qualify for cap exemption purposes.
Right. And whoever asked this question, if you want to direct that either to Lana or Amy Bello, we can certainly follow, ISSS can follow up with you about the particulars of that if you're trying to work for the university or and we can have that conversation as well. This next one is a multi-part question. This person may need to follow up with an attorney directly, but so bear with me a moment. In the case of a J1 STEM student that wants to apply for permanent residence, is the 212E still an impediment? If it's waived, will the process have to go through a transition to F1? I'm not sure I follow this person's question. Hold on. Fellowship.
Can I just maybe tackle it, Tyler? Because we don't have too much time.
Yeah, no problem.
Well, first of all, if someone is subject to 212E, your home residence obligation, they are ineligible for permanent residence until either they've gone home for 2 years or gotten a waiver. So the 212E does need to be dealt with. The next subcomponent of the question, I believe, says that let's say someone gets a waiver, can they go straight from J1 to permanent residence? In theory, yes. The only caveat is, and this goes back to the dual intent issue, that once they file for permanent residence, they would not be able to extend their J1 because, again, it's a contradiction between temporary and permanent intent. So we certainly have had situations where we've gone straight from J1 to permanent residence, but you need to factor into that. When does the J1 expire and what are the extension needs? And then how long is the case for permanent residence going to take? In terms of if you're a postdoc fellowship, how's it treated in terms of OPT or H1b? Again, I think that's something probably to discuss with ISSS, but if it's a postdoc, that's an employment position that would not be amenable to OPT, but it could be for H1b. And then are there any differences in postdocs in a university versus a government research institution or in private industry? From an immigration standpoint, not really. I mean, they can all potentially qualify for J1, but again, it depends on the specific situation.
Right. Okay. Thank you, Bob. Is there a rule regarding how much time you should have worked for an employer before they can apply for a green card for you?
The general rule is no. I mean, if someone is working, and I'm going to assume they're going to be an H1B, then as long as the employer feels committed and confident and committed to the foreign national, you can start permanent residence anytime. In fact, you can start a case for permanent residence even before someone starts working for the employer. So you've got a lot of flexibility there.
Okay. Well, I know we're at time. Lana, do you want to keep going, Lana? We want to be thoughtful about Deborah and Bob's time.
Deborah and Bob, please let us know. If not, we can just save the chat and then reply. email.
we're fine winding things up. We can keep going.
Okay, thank
Okay,
you.
Thank you.
So this person's just asking in general about the possible process of getting an expired visa reissued during this time. So maybe just speaking about what that landscape is looking like for visa renewals lately.
So there, just last week, they did ban for if you have done the same category over the last 48 months, you may qualify for the waiver of the interview at certain embassies, which would help. But there's otherwise you can't renew a visa within the US. You can only do so outside the country.
Right, okay. I'm just trying to see what would be best to answer here. Let's see. For a tenured or tenure track faculty currently on H1B, what do you recommend beginning the EB1B or NIW process?
That really requires an individual consultation.
Right.
I mean, and there actually we've done some work to try to identify some of the key triggers leading to one or the other. But again, it's not one size fits all by any means.
This student says, can I, a student on STEM OPT, move from OPT to permanent residence without doing an H1B if my company decides to do so? The caveat is this student works for CU Denver Anschutz, but I think the answer to that is yes.
Potentially, yeah.
If the timing works out, yeah.
Right. A lot of these remaining questions are pretty particular. I think that it might be best for these folks to just follow up directly. But for those folks we weren't able to get to, I think that we'll just kind of collect your questions, and it might be best for you to reach out to the law firm directly if you have any follow-up, or potentially to ISSS if it's something that we can help with. But I think we'll be good for now, Lana, if you want to bring us out.
Great, I can leave our.
And thank you so much, Bob and Deborah. We really appreciate your expertise and we appreciate your time going over these questions. And just judging by the questions, it looks like this was a really useful session. And if you are a student or scholar at the University of Colorado Denver or Anschutz Medical Campus and we did not answer your questions, we will follow up with you, but please feel free to reach out to us directly as well at isss@ucdenver.edu, and we will answer your question via email. Well, thank you so much. And do you, Bob or Deborah, have anything to add?
No, it's been a great pleasure, and thank you again. But I think that you are going to distribute the slide deck to the attendees, or at least make it available. And, you know, we did review really a huge amount of information. So you may want to go over the slide deck, but with a caveat that everything is in a state of change. So things constantly need to be updated, but minimally, you should be able to use the slide deck for identification of issues and at least some orientation as to what might be coming down the pike.
Thank you so much, Bob and Deborah, and thank you, Tyler and Anna, for joining us today. And I will be sending out the presentation just like Bob has mentioned. And again, please feel free to reach out if you have any questions. And if you posted your questions under Q&A and your name showed up as an anonymous attendee, if you can please email it to the isss@ucdenver.edu, we will address your question then. Thank you again.
Thanks, everyone.